Hello, everyone. Welcome to the Malcolm Renfrew Interdisciplinary Colloquium for Tuesday, February 15th, 2022. My name is Kenton Bird, and with Dan Buckfitch, my colleague from the Lionel Hampton School of Music, we coordinate this weekly series of presentations by faculty, postdocs, as we've heard from the previous 2 weeks, and today, visiting scholars and other distinguished speakers telling about their teaching, scholarship, outreach, and extension activities. Before introducing today's speaker, I would like to share an important announcement about next week's program. 1 week from today, we will be leading up to the Lionel Hampton Jazz Festival, and we are planning to have our first in-person session of the Festival of the Colloquium in nearly 2 years. So February 22nd, our presenters will be the Palouse Jazz Project, a faculty jazz combo. We will be in the Paddock Performance Hall of the Lionel Hampton School of Music building over at Deacon and Blake. And I hope that everyone can join us there. There will not be a Zoom section. So we're hoping that you will come in person and that you'll be masked and maintain social distance in the recital hall. So that is, again, a week from today. If you're on the Renfrew Colloquium mailing list, then you will get a reminder of that later this week. So today's presenter is Cody Trojan, a member of the Idaho Society of Fellows in the College of Letters, Arts, and Social Sciences. He is assigned to the Department of Politics and Philosophy, and he'll bring us an interdisciplinary presentation that crosses between political theory and public law. Professor Trojan's topic is what the landmark case granting LGBTQ civil rights teaches us about interpretation. Please welcome Dr. Cody Trojan.
Hi, everyone. I think I'm sharing my screen now.
You are, and
Okay.
There we go. You've got full screen ahead.
Oh, tremendous, tremendous. Well, thank you all for having me today. It's been so lovely to be welcomed to such a really warm and intellectually vibrant community here at the University of Idaho since I got here as a postdoctoral fellow last fall. I'm so thankful to Dean Quinlan and my department chair, Graham Hubbs, and my colleagues here, Joe and Carrie, in our as the first class of the Idaho Society of Fellows. So thank you for having me here, and thank you for giving me this opportunity to share with you some new work. And as Kenton said, it's interdisciplinary work. And so I'm really eager to have some criticism and comments about how to go forward. My training is as a political theorist, and I'm especially attuned to working through interpretive problems of texts from our broader philosophical kind of intellectual patrimony, people like Hobbes and Rousseau. And I've long been interested in this question of anachronism, which is one of the things as interpreters of these past texts that people in political theory try to avoid various errors and misreading. And as I've kind of made inroads into public law, I'm really fascinated by how the problem of anachronism dominates not only the history of political thought, but also the central questions that occupy us and governing our society in relation to both the US Constitution and what I'm going to talk to you about today, a statute passed by Congress in 1964. And so 2020 was a difficult year for myself, and I think I could speak for most of us. Obviously, our pandemic started and has yet to cease in March of that year, and we had, of course, the most difficult of events in the fall of that year at the Capitol. But there was one, if you're disposed to my way of thinking, at least, there was one really welcome development in the year 2020, and that was that the law changed. The civil rights law in America changed. And for the first time, gay and transgender Americans were now protected by the Civil Rights Act of 1964, in the sense that they now enjoyed the same protection against dismissal or firing because of their sexual orientation or gender identity that other Americans have long enjoyed as part of their protected characteristics of, say, nationality, religion, and sex. And so you might be wondering, well, that's interesting. I don't remember, the 45th president of our republic still presided in the White House. The senior senator from Kentucky led the Senate chamber still. And you might have been wondering, I don't remember the kind of fanfare of that law being passed. And of course, you'd be right not to remember it, because there was no law passed. What happened was a 6-3 ruling by the United States Supreme Court that reinterpreted a law passed over a half century ago to mean something that no one had ever known it to mean before then. And so it's that kind of anachronism, this kind of being in between both past and present and trying to manage that relationship of past and present, that I'm interested in thinking about with you today. And the case was not only so remarkable because of the breakthrough for LGBTQ equality in America, but also because the court at this point was dominated by Republican appointees, and the method of interpretation that had been formed by the conservative legal movement over the past half century had finally achieved a majority of support at the Supreme Court. And so what we get in this decision is an interesting coalition between all the democratically appointed nominees. Were joined, or in this case, led by Neil Gorsuch, the newest member of the court at that time, who President Trump had nominated and placed to confirm to take former Associate Justice Scalia's seat. And so Neil Gorsuch writes this majority opinion of the court, joined by the Chief Justice, John Roberts, and the 4 members who had been appointed by Clinton and Obama. And so what's also remarkable is not just the breakthrough for civil rights, but also this striking division between the justices who all aspire to be implementing the same interpretive philosophy, and yet have not only a different result, but a rather acrimonious disagreement that really divides conservatives in America writ large. And the big question that I'm so interested in, and that I want to maybe invite you to share interest in, is how we ought to interpret texts from the past. And I want to suggest that there are some abiding dilemmas and problems that are of interest in different kinds of texts. And the texts we're interested in today are going to be legal texts. But I'm going to begin with some examples from my more native terrain. And the argument I really want to make to you is that textual originalism, which is the interpretive method honed and prized by the conservative legal movement, harbors a fundamental ambivalence. Okay, it's designed to be a stricture, and yet it's much more limber than its exponents understand. That's the one that my first argument I want to make to you today. And secondly, this ambivalence is really crucial because it undermines the interpretive method's claim to democratic legitimacy. And this is super, super important, because what textual originalism prides itself on is being the single interpretive philosophy that really befits a democratic republic, that really has a respect for what it means for the people's representatives to make law rather than unelected judges. And so if there is some kind of democratic squirreliness there, it's really pivotal for how the method is received and prized. So what I want to do in our time here, and I'll keep my clock handy here, is I first want to give you a couple concepts that I'm kind of using to help map the terrain that I'm going to call the autonomy of the text that an interpreter could privilege, and the heteronomy of the text. And I want to introduce those concepts to you from some examples of political theory that I've worked with for a long time. And then I want to, after I've kind of established those concepts, I'd like to give you a very potted history of the conservative legal movement, insofar as I see it, and it indisputably is a reaction to the interpretive mistakes or perceived mistakes of the Warren Court, and how this emphasis on textualism and originalism were born as a method of, as a kind of prescription to fix what's wrong with how judges read the law. And then I want to go to this Bostick case that we're talking about today, this 6-3 decision. And I want to take you through the majority opinion authored by Neil Gorsuch, and the minority opinion, or the principal dissenting opinion authored by Samuel Alito. And I want to show how they both claim to be using the same interpretive methodology, and yet they kind of arrive at these really diametrically distinct outcomes. And so what I want to suggest there is that rather than somebody making a mistake per se, what it actually reveals is a core ambivalence. And I want to kind of spell out those implications for democracy. And then maybe if folks are interested in the Q&A, I might, one of the things we might talk about, and as a kind of epilogue, is an alternative way that this case could have been decided with a different approach to how to make arguments about how text means, about what text mean, okay? So to begin here, by the autonomy of the text, what I mean, and I'm going to move some of my Zoom, my Zoom bars are all floating around. By the autonomy of the text, what I mean is that everything you could possibly need to understand what a text means is there on the page, that you needn't to go outside the text, and indeed you shouldn't. So the more, this is kind of an ideal type here, but the more you insist upon it, the more you're suggesting that every attempt to decipher a text needs to be intratextual. It needs to refer to the semantic propositions that are there on the page. And at the other extreme, we might speak of a heteronomy of the text, that, you know what, on the absolute contrary side is this idea that, you know what, the text, no amount of poring over the text is going to be enough. We're going to have to make reference to the things that are outside the text, to extratextual reference. So in other words, what the author of the text thought they were doing when they wrote the text, for example. What were the motives of the human agents? What was the broader discursive dialogue conversation going on at the time that led to the adoption of a particular law, or that led Hobbes to write Leviathan or something like that, right? In other words, that the context is going to be really key to really not missing what the text means. So these are my kind of two ideal types here. And I want to give you a sense as to what it would mean perhaps to err. I won't say necessarily error, but to err on the side of the autonomy of the text. And so when I read a text like Hobbes' Leviathan, and I think some of my students are here, and we started reading this text today, and when I read a text like this, there's an important passage that happens in the first part, and I think I know exactly what it means, and I think most Hobbes scholars, we think we know exactly what it means, but it's going to rely upon a broader sense of what Hobbes is doing. And so here's the passage that kind of lands with a thud for political theorists like me. Hobbes says, "For there is no finis ultimus, utmost aim, nor summum bonum, greatest good, as is spoken of in the books of the old moral philosophers." And what I take Hobbes to mean here, and I would say what most Hobbes interpreters obviously take him to mean here, is that everything Aristotle and the scholastics were talking about, these concepts of this greatest good and utmost aim that was going to orient all of our ethical action towards this final goal, all of this was nonsense. It was a nullity. And indeed, my entire project is to prove that entire approach to political and moral philosophy is just dead at the start. Okay, so that's what I take it to be doing, and that's I guess a reading that relies on some context. that's not the only reading possible here. If one was to bracket out all of these claims about what I say Hobbes is up to, you could just look at the pure semantics of the sentence here, couldn't you? Couldn't you just look at the semantics here and really see that if I just look at the text and confine myself to the text, for there is no such utmost aim or greatest good as is spoken of in the books of the old moral philosophers. So that might mean semantically that, well, there's no greatest good in the sense spoken of by the old moral philosophers, but there might be a greatest good in a different sense. Then that's the one I believe in. So that the concept is worthwhile, but just not their version of it, my version of it. And I raise this example because there's a very brilliant, smart scholar at McGill, Arasha Bizadeh, who claims in a recent book that the passage means precisely this. And it just, and it's one of these moments that we as political theorists kind of get just struck by where, oh my God, really? Like, where we have these moments of how could you possibly read it differently like that? How could you possibly take such an autonomous reading when clearly some context was necessary? That's an example of what it means to err on the side of autonomy, maybe to the detriment of context. I want to give you another example from political theory, another really famous example from Rousseau's Social Contract, which me and my students will be reading next month. That kind of goes to the other side, that maybe isn't careful enough to take the text as it is on the page, to treat it autonomously, and too quick to interpret it in light of things outside the text. And there's a famous passage in Rousseau that when my students read it today, usually they're kind of horrified by it when they read the text. And it seems to say, he says that whoever refuses to obey the general will shall be constrained to do so by the whole body, which means nothing other than that he shall be forced to be free. This very idea of somehow being forced to be free, for many readers in the 20th century, in particular, one named Talman, what we really have here is the invention of a theory of totalitarian democracy that he, writing in 1952, sees all around him and the totalitarian systems around him. And so he is very eager to allow his context as a reader to help guide him as to what a text really means. And the reason why, Rousseau scholars like myself try to develop a certain allergy to that kind of reading is because it seems to rely upon a kind of perversion, a kind of weirdness that the text that Rousseau wrote in 1762 has to await 1952, has to await the future in order for us to figure out what it means. That somehow the real meaning of Rousseau's text is only revealed a couple hundred years after the fact. Okay, and so this is a side where I would want to, in my reading, I would probably make an argument that we should take a more autonomous reading and understand this force to be free as this. We could talk about that later, but it's this broader problem of what it means to make a moral commitment at an earlier time, and then what it means to be to have that moral commitment embodied at a later time. Okay, so these are the kind of concepts I kind of want to work with here. That is to say that on the one hand, you might imagine somebody who could excessively privilege the text on the page, the semantics, and that might make that reader in a certain situation insensitive to the context in which the speaker was actually making the utterance. And on the other hand, you could imagine somebody who's really not paying enough attention to what's going on the page, and instead is privileging something from outside it, either something from the writer's environment that means we should disregard what's on the page, or something from the reader's environment, such as Talman's, that leads him to really insist upon a certain reading. For example, Rousseau as theorist of totalitarianism. Okay, feel free. Anyone should jump up a hand if I feel like it to go over anything again or to pause for a second. But now I really want to move to this second moment, kind of having established these two kinds of ideal types of readers, namely to try to talk about how the conservative legal movement was pretty founded on this problem of anachronism, and that's how it really came to embrace and innovate this method of interpretation of legal text that I'm calling textual originalism. And so my potted history, just to give you real quick, to give you the context here, is really that we really need to understand the conservative legal movement as a reaction to the Warren Court, and specifically the way in which some of its most famous rulings were unconcerned with straying from the text itself. And so, for example, one especially egregious case for many Americans is the Griswold case, which is where the Warren Court found a right to privacy in the text, even though, as those of you who might do a quick word search in the Constitution will quickly learn, the word privacy never appears, and yet it's found by a kind of bold reading, and so this is the famous Indiana Law Journal article from 1971 by Judge Robert Bork that became the kind of the spectacle of something very difficult for him to get around in his confirmation hearing in the 1980s, which many people believe was the real moment our judicial confirmation processes in America kind of got off the rails or became so acrimonious, you might say. And so what does he say in trying, as he's groping here to try to forge an alternative to the Warren Court's interpretive malpractice, in his view? He says, if I'm correct so far, no argument that is both coherent and respectable can be made supporting a Supreme Court that chooses fundamental values. Because a court that makes rather than implements value choices cannot be squared with the presuppositions of a democratic society. The man who understands the issues and nevertheless insists upon the rightness of the Warren Court's performance ought also, if he is candid, to admit that he is prepared to sacrifice democratic process to his own moral views. He, that defender of the Warren Court, claims for the Supreme Court an institutionalized role as a perpetrator of limited coup d'etats. Right? So what's really motivating the expressly stated motivation of the need to develop an alternative theory of interpreting the law and the Constitution is in order to preserve democracy, precisely because if judges don't have a strong set of strictures that limit their flexibility and prevent, and if instead they are licensed to read as they may, then what we're going to have is law that can be changed, and even the Constitution that can be changed in a coup-like manner by judges through their licentious readings, the kind of readerly license they take with these texts. So those are the stakes. So the reason why we need this alternative is because of our care for democracy. So what's the prescription going to be? Well, the prescription is going to be, on the one hand, textualism. We have to rely on the autonomy of the text. We have to really fixate on the text on the page. We have to focus on the semantics. We have to shield out anything regarding this claims to intent, the legislative history, all other things that are, what are they going to do? They're going to allow the judge's bias to sneak in. Now, often unbeknown to the judge, unwitting, whether witting or unwitting, they're going to, the more you allow people to make reference and use evidence outside the text, the more you're going to have judges legislating rather than merely interpreting Congress's clear enactments. And so Associate Justice Scalia, and I believe it's 2014, he co-authors a kind of statement book called Reading Law with a man named Garner. And he refers to this, Justice Scalia does, as the supremacy of text principle. The words of a governing text, he says, are of paramount concern, and what they convey in their context is what the text means. And the goal here, and this is why I haven't said it yet, but both this the judicial interpretive method is often called originalism in our newspapers, and I think generally in law journals, that's usually what it's called, is originalism. But Justice Scalia usually called it textualism, and in the Bostic case we're going to discuss in just a minute, that's also what Neil Gorsuch and Sam Alito call it, textualism. So some people say textualism, some people say originalism. They both claim to mean the same thing, but I actually find the inability to settle on a word is actually revealing of the ambivalence of a kind of ambivalence in the method itself. But insofar as it's textualist, the goal is to really focus on the text and to just restrict and limit a judge from looking at other things that might allow them to get around the text. Things like, how was this bill marked up in Congress? What were the committee reports like? What did the congressmen say they were doing when they wrote the law, et cetera? Those kinds of extra textual pieces of evidence that could help you figure out the meaning. Those are going to be heteronymous roots that are going to wittingly or unwittingly lead the judge to insert their own values rather than defer to what's written down. The second prescription is going to be originalism, and it's going to be this idea that, well, when there's any ambiguity in the language on the text, what you're going to do is make sure that the meaning of those words is tethered, fundamentally wedded to the meaning it had when the text was adopted. And so Scalia in reading law calls this the fixed meaning canon, that words must be given the meaning they had when the text was adopted. And so I would submit to you in my quick version that these are the two more kind of cornerstone canons or principles you rely upon as a judge if you're interpreting the law correctly under this school of thought. Okay. And it's so important that you do so because the stakes are so high, and the stakes are so high because, as Scalia writes, originalism is the only approach to the text that is compatible with democracy. The alternative is allowing laws to be rewritten by judges, which amounts to, of course, just a radical departure from our democratic system. And so it's precisely these two principles that are going to give judges the stricture, the kind of discipline that's going to prevent them from allowing their own views to seep in, or just misreading the text by whatever extra textual mistake. So now I want to move to the Bostic case, the main event, and just kind of show you how both the majority opinion and minority opinion rely on the same method and arguably find a similar or reach a rather different conclusion based upon what seem to be the same principles. And so to do so, we have to get some acquaintance with the Civil Rights Act of 1964 here. And so here's some images from our friends at the National Archive of when Lyndon Johnson signed it in 1964 on July. And what Title VII of the Civil Rights Act says is that it shall be an unlawful employment practice for an employer to fail or refuse to hire or to discharge any individual or otherwise to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin. So those are the protected characteristics of an individual that it is unlawful for an employer to use as grounds for firing them. And so the question before the court in 2020 in the Bostic case was, does this sentence right here, and in particular, the only possible applicable characteristic would be sex. So were employees who were fired because they were gay and because they were transgender, were they fired because of sex? For Gorsuch's majority opinion, the answer would, to the amazement of conservatives across the United States, was yes. Gorsuch argues, the majority argue, that to discriminate against gay and trans Americans requires sex discrimination. That you're not going to be physically able to to embark upon this discriminatory firing without attending to the individual's sex. That's his claim. I've highlighted a piece of it here. He says, it is impossible to discriminate against a person for being homosexual or transgender without discriminating against that individual based on sex. And the most powerful argumentative move, in my opinion, made in oral arguments in the briefs, and that Gorsuch inserts in his opinion, is an example. Let's say we have an able employee named Cody, and he marries Sally. Cody's a man, he marries Sally. So what does my boss do? Well, he says, congratulations. He gives me a honeymoon vacation. I go on a lawn vacation. It's all great. Let's say there's another employee at the same firm who's identical in all characteristics to Cody, identical in terms of his work performance, et cetera, except there's only one difference, is that the employee's sex. And let's say that employee marries the same exact person, the same exact Sally. What happens to Janet? Janet's fired for being gay. What was the difference here? They both had the same work performance. They both married the same person. Surely the only difference is their sex. And thus Janet was fired because of sex. I think that's the most powerful, pithy version of the logic underlying the majority's rationale. Okay. Alito is apoplectic. He's apoplectic not just in oral arguments, but in his writing. Often, I mean, for those who don't read these opinions, they're often very colorful. But this one, he's really pulling out all the stops, and he begins his dissent that Justice Thomas joins. Justice Kavanaugh writes a separate dissent that has minor nuances, and Alito says there's only one word for what the court has done today: legislation. So this is precisely everything the conservative legal movement prides itself on allegedly avoiding, right? And why is it legislation? Well, just look at the text. Just like I mentioned in the Griswold case, the words sexual orientation and gender identity are absent. And indeed, in that same year in 2020, Democrats who controlled the House had passed the Equality Act to insert them in there, right? Precisely to insert them in there, but of course it never left. It left the House, but was never taken up in the Senate. And so the very words that would authorize somebody with a textual reading to find in these plaintiffs' favor are missing. And this seems particularly key here to me, and something which I think we need to, in order to really understand the dilemma here, we have to really appreciate that nobody really disputes this in the courtroom or among the plaintiffs and defendants, et cetera. Alito says is, if every single living American had been surveyed in 1964, it would have been hard to find any who thought that discrimination because of sex meant discrimination because of sexual orientation, not to mention gender identity, a concept that was essentially unknown at the time. And so this is something essentially stipulated by everyone, that surely none of the lawmakers in 1964 meant to protect gay and trans Americans, that was, nobody really thinks that was their intent. And so we have the problem of anachronism, of an intent at 1964, and for us today, and maybe the way we see the concept of sex being in tension with how it was seen and understood in the past, and what to do with that mismatch between past and present. And if you have any doubt about what Alito says here, I won't say he takes glee, but he's very thorough in documenting all the ways in which, I mean, if you need a primer on what it meant to be discriminated against as a queer American, he gives quite a primer to document how normal and how committed American society was to the mistreatment of gay Americans, discusses mental illness, et cetera. So he's rather comprehensive in making that case there. And so I guess I want to, as I start to move to the end here, I want to just discuss the democracy point here, and what's so astounding about where Gorsuch ends up here. Gorsuch, in his insistence on the autonomy of the text, says that the limits of the drafter's imagination supply no reason to ignore the law's demands. When the express terms of a statute give us one answer and extra textual consideration suggests another, it's no contest. Only the written word is the law. Not what the people intended, not what the representatives intended, not what they thought they were doing. The words, the semantic words on the page, that is what the rule of law requires. And curiously, then, in this case, the lawmakers have to wait until 2020 to really learn what the meaning of the words they wrote really were. They really weren't in the position to know. Similar to what with the case we looked at with the political theory text in the past. Well, just to show you how upset Alito is, he describes it in these terms. He says the court attempts to pass off its decision as the inevitable product of the textualist school of statutory interpretation championed by our late colleague Scalia, but no one should be fooled. The court's opinion is like a pirate ship. It sails under a textualist flag, but what it actually represents is a theory of statutory interpretation that Justice Scalia excoriated. That theory that the court should update old statutes to reflect current values. And so what I want to really, on the one hand, I guess what I want to say is that there's a clear insinuation that to me is striking when I read it it's almost a kind of up to the edge of implying a certain bad faith to say that one consciously flies a false flag of piracy, that one is trying to fool someone or pass something off as, seems to suggest almost bad faith, which is striking to me. But what I think Alito misses here is I don't think his colleague is so much in bad faith. I think what Alito misses here is the core ambivalence in the interpretive approach itself, namely that textual originalism is an unstable compound, that the textual side of it leans us towards an autonomy of the text reading, and that the originalism or the fixed meaning canon pulls us precisely in the other direction, towards extra textual reference. And so if I could just conclude here briefly. So whereas I kind of see Gorsuch as really strictly adhering to an autonomy of the text and a refusal to look at anything else outside of it, Alito is kind of ping-ponging back and forth, starting with the text and then saying the text can't interpret itself, and I have to go back to how language was used in 1964 to tell you what the words mean. And so he's going to kind of be in between and trying to privilege these extra textual references. And so you can see here how the goals are to protect the meaning of the text in both cases. But whereas textualism wants to discipline the judge by prohibiting the use of all of these other possible kinds of evidence to kind of disallow them that license of making use of them. The insistence that we fix the meaning we index it to a certain time, requires that we do the reverse. It specifically licenses us to look at all kinds of things outside the text to figure out what the words mean. And so the method inherently requires us to be at cross purposes. And I think one core conclusion here is that there's that textual originalism, much to the dismay of its theorists and exponents and practitioners, is just much more limber than they realize. In other words, it's a lot more flexible than it's a lot less of the stricture they think it is, and it actually licenses, in the Bostick case, reaching diametrically opposed outcomes. And I guess I might just close by thinking about there's a certain kind of irony in either direction. There's a kind of risk if we attend too closely to the text that we might take flight and take leave of the very democratic will. We might use semantics of language to take leave of of what the democratic will was of the people or their representatives at a given time. And on the other side, we might there's a risk that in being so eager to fix and index meaning to a certain time, we might inadvertently delimit or just constrain our own imagination. In other words, we might constrain a concept to mean not what it could mean, but we have to substitute our notion of what a concept means to the prejudiced imagination of somebody who originally wrote the language, right? So in other words, there's a kind of limit for what a principle could do in the law, and we could be limited by the prejudices and just failures to imagine of our predecessors there. Okay, and that's where I'd like to close. I'd like to thank you guys so much for hanging out for allowing me to share this with you, and eager to hear what thoughts you might have. Thanks so much. I can't hear Ken.
Cody, thank you for that presentation. Very provocative, especially for those of us who casually follow the Supreme Court to get a little bit deeper into the weeds of what goes into that decision making and the intra-court arguments. And that case especially interesting because of the split in the conservative bloc. I would love to hear some questions from the audience. So anyone who would like to leap in with a question or comment, or if you want to just put a question in chat, I can relay it. But Professor Quinn has a question, so please go forward.
Thank you. That was extremely interesting. Yeah, as a casual court follower, are there any other cases that you could mention that might be explained? I mean, the outcome explained on the basis of this distinction that you've pointed out?
I think, of course. I mean, there's so many. I would even think. I mean, one that comes to mind is Keene v. Burwell, which was another one of the many Obamacare litigation, where Scalia at that point really relied on the law was rather hastily composed, as you might remember, and there were some mistakes in this very long document. And if one took it especially literally and textually, it would require these state health insurance exchanges to really just nonsensically function. And so the argument in the case that Justice Kagan, Associate Justice Kagan, made with vigor in the oral arguments was whether you, well, like, clearly they wanted the health, these state exchanges to work. So they clearly didn't intend to just make it not work. And so in that case, it really required a lot of thinking about the purpose of the bill versus kind of a strictly textual focus on what the law said. So so that would be one case, for example, where and I believe that was I believe the Chief Justice joined Kagan, Ginsburg, Breyer, and Sotomayor. I think that was a 5-4 decision where Alito, obviously Judge Gorsuch wasn't on the court yet, but Alito and Scalia hewed quickly to the textual thing there. So that would be a case there. But I mean, for me, the most striking case, the most kind of striking case that is much debated in law journals and across our country is the Second Amendment case, had the Heller decision, District of Columbia v. Heller, where I might see where you have both the who wrote the dissent there, Stevens wrote the dissent, the four dissenting, but both what you have in the Scalia, who writes the majority opinion, and Stevens there, you have a constant ping-ponging between the words on the text and what allegedly was going on historically in the 1790s, and you have a constant ping-ponging there, and to those, most of the to those of the historical community, historians see a real, the consensus among historians was that was a real, that the court really mishandled the history there. And so, and I think what you might say if you thought the case came out wrong, or whether you wanted to just kind of see what goes on there, is when you can, is this method kind of when you need to lean into the text, you lean into the text. But then when you say that, oh, the text isn't clear, then you can lean into these historical reference in that case. Or, for example, in that decision, a lot hinges on what it means to bear arms, and whether you take those as independent words or whether you take it as a phrase, which meant militia usage, things like that. You're going back and forth. But those were two, the Heller case would be the biggest one for me that I would want to explain through this kind of dynamic as well.
Other questions?
Great. I guess I can attempt a question. But yeah, thank you so much, Cody. This is fascinating, and I probably would need a second cup of coffee in order to really start to wade into some of the very complex issues of legal interpretation you're raising. But I was wondering, I guess the first part of the question was just wondering, do people refer to strict constructionism anymore, or does that kind of intermingle or sort of seek to occupy a middle ground between originalism and textualism? And then would it be sort of the opposite view, is which you alluded to, I think would be sort of the living document kind of way that would oftentimes be critiqued by the kind of right-leaning legal theorists and scholars. So it was, I suppose, terminological. Another thing that kind of came to mind, and this might be wading too much into the details of the case, but I thought the Gorsuch and the statement was fascinating, and I was wondering if you could comment more on the way that kind of the sex-gender distinction came to the fore in this case, as something that we oftentimes use in our classes somewhat heuristically in social sciences or in gender studies, at the same time recognizing that distinction can potentially reinforce some of the binaries we seek to critique. So those two relatively minor points, but thank you again for the presentation. It's great.
Well, in terms of the strict constructionism, I'm a strict constructionist, kind of that kind of talk of that. It often was a kind of signal for the kind of, there was a time, you guys might not remember it, certainly our students don't remember, but there was a time in American politics when political candidates didn't announce who they were going to confirm, what kind of judge they were going to confirm. By my lights, I was really astonished in that debate stage in 2016 when Secretary Clinton said that she was going to essentially appoint a pro-choice judge, and Mr. Trump said he was going to appoint a pro-life. That was an interesting Rubicon we crossed there. But so that used to be a kind of code, a signal that I'm going to appoint judges like Thomas and Scalia. And sometimes they would say in the Mulder, but so that used to be a kind of signal. They would use those words. But Scalia himself hated that phrase, strict. He says so in one of his famous essays, Common Law Courts in a Civil Law System, I think that was put in the end. He hates it because he thinks he doesn't want to be hamstrung by the semantics in a certain way. He thinks that you don't want to read the text strictly. His literal quote was, "You don't read the text strictly. You don't read it leniently. You read the text correctly, in light of the sentences that came before it, essentially, and with the meanings, what they meant at the time of enactment." Right. So, so he didn't like that term. I think Thomas might use that term, or certainly I think Justice Thomas is much more prone to that kind of, to the strictest of possible construction at certain moments. But it's not a term. Originalism or textualism are the terms that those who theorize it, like Keith Whittington at Princeton or Barnett, They call it originalism when they're theorizing and defending it. And then, as you saw, Alito and Gorsuch both referred to it as textualism, which is what Scalia originally kind of referred to it as. The second point was about the sex-gender distinction, which so I think Alito goes over this. I mean, it's gender is a grammatical term in the 1950s. It refers to Latin conjugations of some kind. Where it's about and it kind of, I think it's through feminist philosophy that it starts to sneak into the language as descriptions that we use to talk about ourselves and human beings. And so Alito is quick to point that out. I mean, he's quick to point out that not only did people in 1964 not intend to be doing these things, that they even lacked the whole conceptual architecture to do it if they wanted to. He even remarks, I mean, that it actually was right around 1964, maybe even that same year, that the phrase gender identity first appears. And if you happen to be reading in an obscure psychoanalysis journal, and Alito finds it there and shows it to you, but it was not in the mainstream culture. Or any aside from a small psychoanalytic analysis kind of group. So what's so interesting about Gorsuch's opinion for me, Joe, is how it claims to not be going into this whole question of sex and gender, et cetera. He doesn't even seem to think that there's any. His argument doesn't rely upon any thick connection between sex, sexual orientation, gender identity at all. His framework he's using is essentially sex is a kind of tripwire, and he's not even claiming that sex has anything to do, has any real relation politically, logically, politically, with broader LGBTQ issues. It's only because in order to get to LGBTQ discrimination, you have to trip the sex wire that he's going to invoke it. And so what I mentioned, as another place to go in the Q&A is just if Ginsburg had written this decision, she wouldn't have written it that way. I think she would have had a more common law understanding of how the Civil Rights Act has developed over time. And for me, the key case would be the Price Waterhouse case, where the idea that if you fire somebody for not observing certain sex-based stereotypes was the ruling, then you've really engaged in sex discrimination. And so there could be another version that's really just showing how this is a society through litigation and living has a kind of experienced that sex discrimination is a really complicated beast that actually has many elements, and that it might grow to encompass sexual orientation, gender identity. That might be another way to go with it, and a more common law approach, less textual there. Yeah. I see Dean Quinlan has a hand up if he wants to jump in as well.
Yeah, thank you, Cody. I guess that, this is more an observation than a question, I suppose. But I think what, Karl Schorsky writes that, one of the hallmarks of the 20th century is modernity essentially drains historical understanding from things. That's his kind of his argument. I'm always struck, particularly like with things like, strict constructionism or textual analysis, and you see it in a variety of different contexts, right? From the Austrian School of Economics to new criticism in English, for instance, is this kind of draining of context and how fundamentally at odds that had been to traditional conservatism from Burke forward, right? Is that the context is the whole story, right? That's the meaning. And anyway, so it's a kind of puzzle in which we have these kind of debates about. Is about kind of the formal elements of the meaning there, and how history is allowed or not allowed to kind of come into those discussions. Observation less than a question, but I was thinking about that throughout the course of your lecture.
Yeah, what I would recommend to you, I don't know why I'm blanking on his name. I keep reading him, and Burwell is who I'm thinking, Adrian Vermeulen. He's the one I would go to. He writes. He was a former clerk of. He's a friend and colleague of Cass Sunstein, and he's a former clerk of Justice Scalia, and he wrote this astounding piece. Where was it? It wasn't in The Nation, maybe the Atlantic, maybe, suggesting that conservatives have done with textualism and adopt a common good constitutionalism, he said. And this created a huge furor in the Federalist Society and conservative legal circles. But essentially, and when in his writings, he kind of invokes the kind of Burkean mold here. And so, yeah, if conservatism means Burkeanism, then it's common law all the time, right? There's an incredible wisdom to be had there. But that's kind of what's so fascinating to me, and I think why Scalia and textual originalism is so misunderstood is it has a real Rousseauian flavor on one level, which is to say that, my goodness, what the people willed has to be respected to the letter. And it's not the place of their delegates to somehow challenge that sovereign willing that they did in the Constitution or in a legislation. And so what it means to preserve that democratic will means to defer to that popular enactment, right? And so, in other words, the common law has a much more aristocratic conception of what, and so actually Scalia, at least, this is the express justification, is that it's an anti-aristocratic impulse. He sees it as part and parcel of the whole codification of law movement from the levelers to the 19th century. That is to say that we don't have judges, wise men who know the law, and the common people don't have access to it, but somehow that it's all written down, it's codified, and judges are constrained to obey it, right? That the judges aren't.
So history, like this is anyway. Sorry, and then we'll go with the. But like history enters in at a historical moment, right? It's a moment, like the general will is like there,
Yes.
But then it somehow like stops. It's it like ossifies or glaciates or whatever, is that like you have like history entering into the story, but then it like ends, and then like there's
right. Well, that's what I would call the kind of I don't want to overstate it, but there's a kind of there's something that comes with this "don't you believe in democracy" rebuke. I mean, in the case of the Bostic case, it's actually pretty easy. If the case had gone the other way, we had the Equality Act. If enough congressmen vote for it, we just change the law, and the Civil Rights Act means that. But of course, when it comes to Heller and constitutional questions that aren't about, then Congress can't change it. And in our system, it's so incredibly difficult. So Scalia would say, well, if you don't like, if we don't like the Second Amendment anymore, why don't we amend the Constitution? But the joke there, or the rub there, is that it's extraordinarily difficult to amend the Constitution. And so if the judges do get it wrong via some kind of anachronism, then not because of any judicial method, but because of our system, we don't have the democratic means of overcoming that. We do when it comes to statutes, I would still say pretty possibly, but when it comes to a constitutional thing, then it requires, of course, 3/4 of states to ratify it. And so that's this kind of, on the one hand, this kind of enthusiasm for democracy, but kind of muting the point that you would require a real kind of massive super majority of everyone to ever kind of revise that democratically. So that's what keeps history out, is the onerousness of our amendment process. That's what keeps history out from coming back again. And if it could come back again, then the method is not going to have those problems. If we had a more popular constitutionalism like they have in other countries, it wouldn't have posed those problems anymore, it would seem.
I'm afraid we're at the end of our hour together. So thank you very much, Dr. Trojan, for engaging with us, as well as those in the audience who had questions or comments that helped us explore the topic a little more deeply. Before we thank our guest, I have two announcements. First, I'd like to invite the students in INTR 450, Annika and Ben, if you could just stay in the Zoom meeting after we wrap up the seminar. I have a little scheduling question for you too. And then for everyone, to remind you that next Tuesday, February 22nd, we will be live in the Haddock Hall of the Lionel Hampton School of Music on stage with a jazz combo with a program called How to Listen to Jazz, which will be our preview of the 2022 Lionel Hampton Jazz Festival. There will not be a Zoom program next week. You'll have to come in person with your face mask on and be socially distanced in the music recital hall. So in the remaining minutes, if you wanted to put up your hand in Zoom or offer a round of applause to Cody Trojan for a fascinating presentation. Keep up the good work, and we look forward to interpretations of future Supreme Court cases through the lens you've presented us today.
So much, everyone.
Thank you, everybody, and we'll see you next